Hello. In this clip from our Justia webinar, Logic for Lawyers, Crafting Persuasive Legal Arguments, Brian McCarl discusses conclusory reasoning, walks you through different examples, while talking about the importance of conclusory reasoning within your arguments. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
So the reason that that makes it so urgently necessary to think about legal reasoning, if you're a lawyer or a law student, is that it's just so sometimes our view of a case gets so rooted in our in our being that we forget that there's other ways to see the case and the case's facts and legal arguments, or we start to see things as self-evident, and so we forget to make sure that we elucidate our premises and really look at our arguments from a skeptical perspective about how they might be challenged by opposing counsel or a skeptical judge. So the most common mistake that law students make and the practicing lawyers make as well is what lawyers call conclusory reasoning, which essentially is not reasoning at all. It's just asserting a conclusion without specifying reasons to accept the conclusion or without adequately identifying and supporting contested premises. So the general rule of thumb, and really the most important concept that everybody should learn in law school and remind themselves at all times when they're writing, is that if a statement is disputable, if there's grounds to conceivably dispute it, then it should be defended, and it'd be defended by legally cognizable reasons such as citations to binding authority. There are many varieties of conclusory statements, and I talk about some in the book, and I'll just run through a few examples now to sort of maybe catch yourself. Maybe if you see some examples, you'll start to catch more examples of conclusory reasoning that makes it into your own drafts. And realize that maybe there's a need to back certain statements that you didn't do the first time around and can improve in a revision. So there's, of course, the familiar bare legal conclusion, such as the defendant's liable because they breached the contract. It's called begging the question in philosophy. It's not an argument. So an acceptable version might be that defendant failed to deliver the goods as stipulated in the agreement. So you're adding the facts that show the legal conclusion and compel the legal conclusion to be reached without just asserting that the legal conclusion applies. A lot of students, especially, I think I partially blame the CREAC model for this, but a lot of law students and lawyers over rely on rule statements, which are not complete reasons to support any argument because they always have to be intertwined with facts. So you'll often see something like this, like these next two examples, where you have kind of a dwelling on the rule statement or repetition of the rule, kind of masquerading as an argument. So first example is, because the Fourth Amendment bars police use of excessive force, the arrest violated defendant's constitutional rights. Again, it just assumes the conclusion without defending it. And it also is stated at such a high level of generality that it's untethered from the specific facts. It just essentially repeats the rule statement. So an acceptable alternative might be, the police used excessive force by striking the defendant while he was restrained and posed no threat to the officer's safety. Then you'd probably follow that with an analogous case that supports the proposition that striking a restrained arrestee is excessive force under the Fourth Amendment. Another variety is to list elements plus a conclusion, pretty similar to the previous example. For example, defendant is liable for negligence because he fell short of the duty of reasonable care and, as a result, injured the plaintiff. The elements of negligence are duty, breach, causation, and harm, and all that sentence does is assert that they are met in a case. Again, it's not an argument. So a better example might be something like, defendant is liable for negligence because he failed to repair the hazardous staircase that collapsed under the plaintiff. Again, so you'll notice that in each instance, it's the addition of specific facts and that speak directly to the elements of the rule. That is the essence of legal argument, and that step can't be skipped. couple more examples. You have what's called an intensifier or intensifying adverb, statements like clearly or utterly, or maybe even indisputably, black letter law, all sorts of statements that we have. We have a whole lexicon of them because this is so tempting to do when we argue. We just, things seem we actually so often believe that something seems so self-evident, surely it doesn't require explanation. But in fact, we have on the other side oftentimes a capable opponent who is capable of challenging it, and that's their job. And they may do it effectively, especially if we don't adequately argue for our own premises. So an intensifying adverb, like clearly, cannot by itself, it can never provide any kind of backing. It's not a reason. It's just kind of a banging of the table. And in fact, it often, as I discuss in the book, arouses skepticism in the reader and makes a statement less convincing because opposing counsels and judges and even jurors are skeptical listeners or readers, and it's their job to filter what you're saying to test its truth and test its accuracy and reasonableness. And given that that's the posture that they're in, they're not inclined to just take your word for it because you say clearly, for example. So, as an example, the agreement is indisputably enforceable. Doesn't add anything to your argument. And an alternative might be the agreement's enforceable because it satisfies the requirements of UCC Article 9. And then you pick the contested or disputable elements of Article 9 in this case, and then defend them. Legal conclusion masquerading as fact. So, for example, plaintiff's recovery is barred because she had the last clear chance to avoid the accident. Last clear chance is a legal term of art that you have to defend before just asserting that it applies. So, an alternative might be plaintiff could have avoided the accident by swerving or braking, but was too busy looking at her phone. Legal characterizations masquerading as facts, similar to the row above. Defendant unlawfully accessed the secure servers and downloaded plaintiff's proprietary information. And an alternative might be defendant found Jones' password and used it to log in to the company's intranet, and he then downloaded plaintiff's customer list. So it's adding factual specificity once again that's tied to that essentially fills in those legal characterizations or supplies the information for the reader to understand that the rule condition is met. And then finally, the last one, we have unintelligibly vague allegations, such as plaintiff downloaded defendant's artificial intelligence and predictive analytics, which are trade secrets. Trade secrets is a term of art. If this is a trade secret case, then we have, again, assuming the conclusion that you're trying to prove. But also you have this other component of this example, which is what on earth is meant by the terms artificial intelligence and predictive analytics. I'm sure you've all experienced a lot of marketing across the internet in the legal tech world and in the world more generally, where everybody wants to say now that their software includes AI. But what's interesting is that they've been saying that oftentimes for maybe 20 years, and only recently have you had the big revolution in AI with ChatGPT and the other LLMs. In a courtroom, a statement that a company's lawyer's statement that their software uses artificial intelligence just doesn't get you very far and doesn't have a lot of content to it. So an alternative might be plaintiff downloaded defendant's patent protected software, allowing dealerships to predict when a customer might buy a car.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.